I guess we could begin. Vivian, I muted everyone because there's a lot of sound that was coming out. If you wish to say anything, you could just turn on your mic. So you could actually just click the mic icon there. So you could actually start speaking. But I had to mute it from my end. Ah, okay. Yeah. Yep. So I made it a rule to just mute everyone because otherwise there would be too much background noise from everyone there. But if you wanted to say something, you could just turn on the mic. So we could probably begin. So tonight we're going to be talking about the topic on law, fact, and evidence. But before we begin to talk about the tutorial questions, was there anything that any of you might wish to take up or discuss or ask about? None? Okay. Let's see. Now, so tonight's topic is going to be on the law, fact, and evidence. But before we do that, I wanted to address the two cases that Kim Easton had the chance to share with us the last time when we were talking about natural justice. So if you will recall, one of the questions there related to the fact that some government officers raided a business entity according to the scenario that I created, even without giving that businessman an opportunity to be heard. And the question was whether or not that breached the rules of natural justice. And Kim was able to show to us two cases. One was about Borenstein, and the other one was the Footscray Club. And I've had the occasion to go to read both cases. And again, for emphasis, those were actually decisions made by state Supreme Courts. And in both cases, they actually upheld the common law principle that there is a requirement that tribunals must act and observe the rules of natural justice. So both cases, which are decisions of state Supreme Courts, emphasize the common law principle that the rules of natural justice must be observed when the actions or decision of an executive officer or tribunal have the effect of interfering with or violating the rights, interests, or legitimate expectations of persons. So that is the same rule as stated by the High Court in Kiowa versus West. Now, the case, however, of Footscray Football Club emphasized that, again, this is consistent with the decisions of the High Court, emphasized that where the Parliament indicates in express terms that natural justice should not be observed, then in that case, that express statutory provision will displace the common law principle that the rules of natural justice should be observed. So let me repeat. There is a common law principle, meaning it is a rule observed by courts. And it doesn't require, therefore, any statutory provision to that effect. So there is a common law rule observed by the courts that when a decision or action of the executive interferes with or violates the rights, interests, or legitimate expectations of individuals, the rules of natural justice must be observed. So that's on the assumption that there is a common law right or interest or legitimate expectation that is involved. Now, that common law rule will be displaced if the Parliament passes a statute that expressly provides that the rules of natural justice will not be observed. So if that were the case, the rules of natural justice will not apply. So if you will notice, if you look at the ACO legislation, for example, the ACO legislation, the one on the Australian Security Intelligence Organization, clearly states that there is no need for the police, for example, to inform someone that their house is about to be raided, because that will obviously negate the element of surprise and would then give the other party an opportunity to hide documents or destroy evidence. So in that case, the ACO law is quite specific in saying that the rules of natural justice will not be observed. But in the absence of an express statutory provision, which provides that the rules of natural justice will be observed, there is a common law rule that the rules of natural justice should be observed in the event that the action of the executive will interfere with or violate the rights or legitimate expectations or interests of private individuals. So I just wanted to make that clear. Any questions so far before we continue? So none now. So tonight, we're going to be talking about, as I said, on the law, fact, and evidence. And after studying this topic, you should then be able to discuss and explain no evidence as a ground for Judicial Review Act, common law, no evidence as a ground for judicial review under the ADJR Act, and the rules of evidence and fact-finding by administrative tribunals. So let's begin. Can I ask someone to read problem 24 for us? And just please turn on your mic if you would be prepared to read the problem question for us.
Okay, I'll start off.
B, yes.
This is B, yes. In Australian Broadcasting Tribunal versus Bond 19, Mason CJ said that Section 53B of the ADJR Act was directed to proof of the non-existence of a fact critical to the making of a decision. In Kurat, Queensland Mining Limited, and Daniel, Black CJ said a decision may be flawed, whatever the relative importance of the fact. He said, if a decision is truth-based in the sense I have described on a particular fact for which there is no evidence and the fact does not exist, the decision is flawed, whatever the relative importance of the fact. Was the decision of the full federal court incorrect, Queensland Mining Limited and Daniel, inconsistent with the statement of Mason CJ of the High Court in Australian Broadcasting Tribunal and Bond?
Thank you, B. So can I ask everyone to please post his or her answer in the chat box? So is there an inconsistency in the statements? So in other words, is it possible that Chief Justice Black was actually wrong? Because obviously the High Court decision is the precedent and it overrides any decision of the federal court. So the federal court is meant to follow any judgment of the High Court. So according to Chief Justice Mason in Australian Broadcasting Tribunal versus Bond, if you look at Section 53B of the ADJR Act, it must be directed to proof of the non-existence of a fact critical to the making of a decision. And yet Chief Justice Black in the federal court seems to be saying something different. Is there an inconsistency or not? Oops. Can I get the response as well of the others?
Manjo,
Yes.
I must admit I was a bit confused with this, and I read them a bit around in my head, but I think they were inconsistent.
They were inconsistent?
In the fact...
Consistent or inconsistent? I kind of missed that.
No, they were inconsistent.
Yes.
I think in ABC of the Bond case, they were saying the fact must be proof of the non-existence of a fact critical to the making of a decision. And yet Black J was saying, well, not necessarily. Didn't have to be critical to the making of a decision. It could have been something along the way that may have happened. Is that right?
Yes. So what do you think? So you're saying there is an inconsistency. So
yes, that's what I'm saying. That's what I argued in my response.
Yeah. So therefore, Chief Justice Black is likely wrong.
Probably.
Yeah. Okay. How about the others?
Hi Audrey. The way I read it was, I think what Chief Justice Black was trying to say was that even if it's not like the critical fact, if there is a chain of reasoning, like A leads to B leads to C, if one of those links in the chain of the logic is based on an incorrect fact, then it does become critical. A single small fact may be critical to an overall chain of reasoning, and therefore, even though it's only a small fact, it may itself be critical.
Okay, so therefore, okay, what's your answer here?
So my view was it's not inconsistent.
Okay, so
justice.
Can you just repeat that for us again? So why do you say that there is no inconsistency? Are they actually saying the same thing or not?
No. So I was just saying that I thought that there is no inconsistency, and that because Justice Black indicated that a small factual link in a causative chain, even though it's small, it's critical in the sense that if it did not exist, then the whole chain is broken. And if the chain is critical, then any single fact in the chain is critical.
Okay. And what has that got to do with the... So what if a fact is unimportant? What is the...
Well, if it's unimportant, then I don't think it would apply as per Bond. But I think what Justice Black was saying, there will be circumstances where a fact may be small in the scheme of all the facts that are considered, but if that fact forms part of a chain of, he says here, a small factual link in a chain of reasoning, if it is truly a link in a chain and there are no parallel links, may be just as critical to the decision and just as much a fact upon which the decision is based as a fact that is more obvious of immediate importance.
Okay, thank you. So Kim, my question for you is, assuming you have a fact that was relied upon in arriving at a decision, but that fact is unimportant, would that mean that the decision could actually be impugned or attacked? And you can then cite Section 5.3b of the ADJR Act to question that decision. So
no, I don't think so. I think it needs to either be an important critical fact itself, or it needs to be a fact that becomes critical because it forms part of a link of reasoning.
The other question is it possible for an important fact to actually be critical to a decision? Or does it mean, therefore, that critical and important are actually one and the same? Or can you contemplate a situation where a fact is actually unimportant, but is actually critical to the decision? And for which reason, even if that fact is unimportant, if it becomes critical to the decision, then it can be the basis for an attack against the decision.
Yeah, and I think that's what happened in Curragh Mines, where the decision maker formed the view that they could have altered the the delivery date for the coal, when in fact, so that in itself isn't a particularly important fact, but because everything else was built upon that, then it became a critical fact.
Mm. Good. Comments from anyone before I say my piece? Comments, questions? So thank you. As pointed out correctly by Kim here. Okay, there. From B, let's put it here first. Hold on. So from B, the decision. No, not that one. It's not coming out. So from B, can be unimportant, but can become critical if it is a link. It becomes critical. Okay, hold on. I'm not able to copy and paste it. Okay. So the correct answer here is that there is actually no inconsistency between the two statements. The statements of Chief Justice Black in the federal court and Chief Justice Mason in the High Court. And we must remember, as we said, that in the scheme of the court system of Australia, the federal court is supposed to follow the ruling of the High Court in the same manner that state courts must follow the ruling of the High Court because of the hierarchy of the court system. Now, there is no inconsistency between the two because they both actually state that if a fact is critical to the making of the decision, the fact that that fact is non-existent would mean that the decision can then be impugned. Now, the question is, how important must that fact be? That fact can actually be important or not. So even if you have a fact that is unimportant, but that fact becomes critical to the making of the decision, and that unimportant fact, in fact, does not exist, then you can cite Section 5.3b of the ADJR Act to attack that decision. So the question ultimately then is, was the existence of a fact critical to the making of the decision? That's the sole question there. Now, on the one hand, that fact can be important. On the other hand, it can be unimportant. But even if a fact is unimportant, if that fact is critical to the making of the decision, and the decision, and that fact critical to the decision does not exist, then you can cite Section 5.3b to attack or impugn an administrative decision. So they were both saying the same thing. At the end of the day, the question is, was that fact critical to the making of the decision? If that fact was critical to the making of the decision, even if that fact happens to be unimportant, for as long as that unimportant fact is critical to the making of the decision, and that unimportant fact, in fact, does not exist, then in that case, there would be an occasion to impugn the decision on the basis of Section 5.3b of the ADJR Act. Clear? Okay, so we'll move on now to, oh, Jacob, you have a question. Go ahead. Jacob, I saw here, yes.
I was just, earlier when people were talking about, the link in the chain,
yes,
of reasoning, when I was reading the notes, wouldn't it not matter? Because they said it's not an error in law. Faulty reasoning isn't an error in law. It's lack of evidence will lead to that error in law. So if you're putting that into your answer, wouldn't that be sort of, I don't know, unnecessary to chuck that in? I just didn't see the significance of saying, if there's a weakness in one of the facts, one of the links of the chain of reasoning going to the decision, I would have thought it makes no difference, because you can come to a decision on, bad reasoning. It doesn't matter. As long as there's evidence there,
Yes.
As long as there's information, not just speculation or...
Okay.
Anyway, maybe I didn't explain.
Actually, Jacob, you're actually right in raising that point. You're actually right in raising that point. Now, but in relation to the fact that there is a reasoning in a decision, the reasoning is actually based on facts that the court is required or may not be required actually to appreciate. Because sometimes it's possible for a court not to actually consider evidence. But
well, they were saying, like further on, to do with tribunals,
yes,
one of the things was that they're not obliged to follow the rules of evidence. It's not a binding sort of thing. They probably would, but I thought, I just thought, my first reaction to that was, that's shit. I mean, shouldn't they have to follow the evidential rules in any sort of adjudication when they're coming to a decision with law? But
okay,
yeah,
okay. There are two aspects to the discussion here. The one aspect is the question of reasoning behind the decision. The other one is the facts that were considered in arriving at a decision. Usually, when a court arrives at a decision, it follows the trail of evidence that is there. It considers facts. So on the one hand, a decision can be impugned because the decision seems to be illogical. It seems to be unreasonable. When we say that the decision is illogical, it doesn't have to suggest that it is illogical on the basis of the facts. It can simply be that the chain of reasoning is faulty. Now that is separate from the question of whether or not facts were actually considered, which shouldn't have been considered, or facts were critical to the decision when in fact those facts were non-existent.
Well, that's, yeah.
So the
problem 24 is about the existence of evidence.
Yes.
Not about the method of reasoning.
Yes.
Yeah. That's what I meant to say about the links in the chain of reasoning. I thought that was shouldn't have been included in that problem, in the answer to that problem.
Yes. So
I wouldn't include it anyway.
Yes. So those are actually two different grounds. So the question of the reasoning being wrong, because remember, as a general rule, judicial review will not lead to a decision being set aside on the basis that the reasoning is faulty or wrong, or that it is illogical. Judicial review is not the proper remedy to cure that defect in reasoning. That is the decision of the High Court. Okay, so an illogical decision will not mean that the decision can be set aside. The only time that you may set aside a decision is that because of its being very illogical, you are then suggesting that it amounts to Wednesbury unreasonableness, which can both be a common law ground as well as a ground under the ADJR Act. But that set of grounds to impugn a decision is separate and distinct from that which is found in Section 5.3b on whether or not there is sufficient evidence to back up the decision. Because then the question for us is, when the decision was made, was a decision based on a fact that was critical to the making of the decision, and that fact actually did not exist? That is distinct from the reasoning side. It's all a question about whether or not the fact which was critical to the making of the decision actually did not exist. Okay. Now, from Michael, Chief Justice Black also cautioned about the reading of Section 5.3b alone, and that it must be read in conjunction with Section 5.1h. He said there must be an absence of evidence or other material of a particular fact upon which the decision was based. Okay, so that is exactly the general rule there. If you have a decision and there is an absence of evidence backing up the decision, then that decision becomes contrary to law. There is an error of law in that case. So both under the common law and under the ADJR Act, therefore, that decision can be the subject of judicial review and the courts will set it aside. Because in that case, there is a decision where there is an absence of evidence. But apart from that, it might be that the decision was actually based on evidence. But in that case, the evidence in this case is a fact which was critical to the making of the decision, but that fact actually did not exist. So that is a separate ground altogether. Okay?
But you don't need each thing to satisfy or to get the decision reviewed. It could just be is it Wednesbury rules? Unreasonableness. That could be a grounds.
It could be.
No evidence. You don't have to have them all together to proceed, do you?
No.
You pick one.
Yes, that's right. So judicial review will become available, and a decision could be set aside on any of those grounds. Remember the rule is any of those grounds, if they are present, can lead to a decision being set aside. But if you are, if you were going to be the solicitor and you're dealing with an administrative case, what you would then do is to identify as many of the grounds as possible on which you attack the decision. So if you can cite Wednesbury unreasonableness, if you can cite the fact that there is no evidence, or you can cite the fact that a decision is based on a fact critical to the making of the decision, and in fact, that fact did not exist. So you cite all of those grounds in your application for judicial review. And the reason is, assuming that your one of your grounds isn't accepted, it might be that the court will accept your other grounds in your application for judicial review. So you should be citing as many grounds as possible in your application for judicial review. Now, let's proceed now to the next tutorial question. Can I ask someone to read this tutorial question for us? Volunteer?
I'll read it, Manjo.
Will it be-
I'll read it for you.
Thank you. Thank you, Elizabeth. Yes, go ahead, please.
Cornelius James, a senior manager of the Department of Social Services, was fired from his job after the Department of Social Services investigative panel found him to have committed sexual harassment against Jill Lockwood, his subordinate. The disciplinary proceedings against Mr. James has been based on the Public Sector Ethical Standards Act, Commonwealth, which prohibits sexual harassment. In its decision, the DSSIP gave more weight to the lone and uncorroborated statement of Ms. Lockwood that on the 23rd of March, she had been groped by Mr. James while she was at his office. Mr. James, on the other hand, presented evidence of his good character and lack of history of any allegations of sexual harassment. 8 witnesses who were just outside the office of Mr. James when the alleged incident of sexual harassment was supposed to have occurred also gave evidence that the incident could not have happened. Mr. James asserts that the DSSIP decision is unlawful since it is totally unreasonable, illogical, and contrary to overwhelming evidence and is patently based on factual errors. He has come to you as a solicitor for advice. Advise Mr. James on the validity or invalidity of the decision of the DSSIP.
Thank you, Elizabeth.
Thank you.
Can I ask everyone to post his or her answer in the chat box? So I'm just going to read some of the answers here because they're quite long. Or you could actually just read your own answers. Would anyone wish to take the floor to explain his or her answer?
Hi, Manjo, it's Catherine.
Catherine, yes.
Hi there. I don't think that James will be successful in applying for a judicial review. There's been no error of law. There's been simply a wrong finding of fact.
Mm-hmm.
Put it simply.
Okay. Why isn't there an error of law?
Sorry, there's no error of law. It's simply an error in finding of fact.
Uh-huh. Okay, Catherine, if you could, why isn't there an error of law? He's saying that the decision is totally unreasonable, illogical, and contrary to overwhelming evidence. That's his assertion. I mean, after all, if you look at the facts here, what did the facts say? There are 8 individuals, I think, who said that it couldn't have happened. And, you know, so there are 8 witnesses who said that, who were there outside the office of Mr. James. And they were saying that the sexual harassment couldn't have occurred. On the one hand, so that's the important thing. On the other hand, there's the lone and uncorroborated statement of Ms. Lockwood that it happened.
That's still a finding of fact, though, not a finding of law. It might be totally unreasonable. It might be illogical, contrary to overwhelming evidence, but it's based on facts and not on law.
Okay. Comments from anyone? So I'm gonna put the answer here of Libby. Yep.
Yes, I totally agree with Libby. Also, what I want to say is that the rules of evidence, which we mentioned earlier, applying in civil and criminal litigation, do not apply in administrative decision making. The investigative panel can receive any material submitted by the parties. It can be hearsay, it can be an opinion. They generally do not obliged to cross-examine or to test the reliability of the evidence. while they're required to act judicially, rationally, and reasonably, they can receive evidence not admissible in court as long as they shoulder the responsibility of being reasonably satisfied, as in the case of Minister of Immigration and ADJR 2, on each component issue, such as Ms. Lockwood's account. And there is no onus of proof on the parties to the proceeding to prove a factual claim to the satisfaction of the panel.
Okay, that's good. Now, so what is the correct answer here? I mean, so in sum, can somebody just summarize for us the answer to the question here? So was the decision of the DSSIP valid or invalid?
Valid.
Okay, because there is no error of law. So if we're approaching this from the viewpoint of a judicial review, then for as long as there is in fact evidence on which the decision is based, even if there might be a dispute as to what the proper decision should have been, but the fact that there is evidence will mean that there is no error of law. So in this case, the fact alone, for example, that the statement of Jill is by her lonesome is uncorroborated will not diminish the fact that there is evidence still that backs up the decision. It is only when there is an absence of evidence that it can be said that there is an error of law, because the absence of evidence to back up a decision amounts to an error of law. But if there is evidence to support the decision, even if there is a mistake in the appreciation of the evidence, that will not amount to an error of law. So that is the rule. So in this case, if you follow the case of Minister for Immigration versus ADJR 2, for as long as there is evidence that would justify the decision, even if there might be a dispute as to the value or the weight of that evidence, that will not lead to the conclusion that there has been an error of law. There is only an error of law if there is no evidence that would justify the decision. In this case, there is in fact evidence coming from Ms. Blackworth. And as pointed out by B initially, so B, I've got a question there. Why did you raise the point about the rules of evidence not being important or not being strictly adhered to?
No, I didn't say that the rules of evidence are important, but they are not to the same strictness or level as those applied in the civil and criminal litigation. I believe the term they use there is like probative evidence that can lead to a decision, but it doesn't have to be beyond reasonable doubt, or at the most it would be only at the level of a balance of probabilities, but it can actually be less as long as the panel is reasonably satisfied with their decision based on that evidence.
Let's clarify that, because we know that as far as a merits review is concerned, in a merits review, the rules of evidence are actually relaxed. So the tribunal, under the law, and for example, under the Administrative Appeals Tribunal Act of 1975 Commonwealth, the law is quite specific in saying that the rules of evidence should not be strictly adhered to, because the purpose of having the AAT Act of 1975 mainly is in fact to ensure that there is good administration. So therefore, for that reason, the rules of evidence are not strictly adhered to. In the context, so my question is, in the context of a judicial review, does it mean that the rules of evidence are also not strictly adhered to? Because that's what I heard you suggesting.
I don't mean in a judicial review. I mean as it applies to the tribunal making the panel, the investigative panel making the decisions. They are at the liberty to make use of whatever evidence they want to use, not as when the court is reviewing this decision.
I see. Okay. So that's fair enough. So that's right. So as far as the DSSIP is concerned, they are not really bound by the rules of evidence. which are observed in courts. But if you have a judicial review, the rules of evidence apply in the course of a judicial review, which is why it's easier to prosecute an application for a review of a decision if you bring it to the AAT, because the rules of evidence don't really apply. Now, however, as far as the DSSIP here is concerned, as correctly pointed out by B here, there is no requirement that the DSSIP has to observe the rules of evidence. The relevant question, though, is there a requirement for the DSSIP actually to act judicially, in the sense that they should accord the rules of natural justice, for example? They should observe the rules of natural justice and ensure that when they arrive at a decision, they should back up that decision by evidence. Is there such a requirement?
Well, they have to definitely give James the opportunity to be heard, and probably they're still held to some kind of standard. They can't just go and make these decisions, and they will look at, if they're going to make a decision based on evidence it's not corroborated, that will reflect poorly and may be grounds for challenge, which is probably James's best bet, that it's uncorroborated evidence that they're making a decision on.
Okay, so the relevant question I'd like to ask is there a requirement for the DSSIP to act judicially? Among them, including the need to observe the rules of natural justice, assuming that the law which created it has not made that provision. So in the absence of a provision that created, for example, this specific, as far as the DSS is concerned, is there a requirement that it should observe the rules of natural justice, assuming that the Public Sector Ethical Standards Act does not so provide? So if the Public Sector Ethical Standards Act does not provide that the rules of natural justice must be observed, is there a requirement that the DSSIP should observe the rules of natural justice? Let's begin with that basic question.
Yes.
Why?
Isn't there a common law
Yeah, common law.
sort of principle that protects us from executive power? So that's all I've got. I've got nothing else. All I could say is yes, common law, but I couldn't point to anything.
So that is correct. So again, we go back to the basic rule observed in common law, that when an executive such as the DSSIP makes a decision, and that decision has the potential to violate or interfere with the rights, interests, or legitimate expectations of an individual, then they are required to act judicially and observe the rules of natural justice. So part of it is the rule on procedural fairness, meaning they have to give the other side or a party an opportunity to be heard, and that their decisions, therefore, must be based on evidence, because that is what the rules of natural justice also requires. Now, the other question that we have here is, why have we already limited ourselves, it would seem, to whether or not judicial review is available? What is the reason for that? So in the first place, how can we say that judicial review is available? Is judicial review available in this instance? Can you argue that judicial review is actually available? I mean, what is the basis for the jurisdiction of a court? So before we can talk about the validity or invalidity of the decision, we have to ask the question whether judicial review is available in the first place. Can we say that judicial review is available, and on what basis can you make that argument? What kind of judicial review are we saying here? Are we suggesting here? Can somebody explain that to me?
Is it the no evidence ground
Okay.
under common law?
So remember, there are at least two aspects, for now, there are at least two aspects to judicial review. So far, we've touched upon the grounds for judicial review. So there seems to be a ground for judicial review, which could be an error of law or the absence of evidence. That could be the ground for judicial review. But in the first place, what is the basis for the court having jurisdiction to undertake judicial review? Are we basing it on the ADJR Act, or are we basing it on the common law jurisdiction of courts to undertake judicial review, or are we basing it on Section 39B of the Judicial Act of 1903? Or is it based on Section 75 of the Constitution, which means, therefore, that we're speaking of constitutional judicial review? Because again, the ground that you cite has to be connected to the form of judicial review that you are undertaking or that you're applying for.
You there, Manjo?
Yes.
Would it be under Section 3 of the ADJR Act?
Yes.
There must be a decision, must be of administrative character.
Yes.
It must be one made under an enactment.
Yes.
And not otherwise excluded.
Okay. So on that basis, we're suggesting that the ADJR Act applies. Correct? Because this is an administrative decision which was made on the basis of an enactment. Is that correct?
Oh, nothing saying otherwise.
Okay. Can it also be said that you can actually apply for judicial review under common law? And what is the significance of doing that? So we're just having a review here, kind of. We're trying to integrate what we've previously known. We're trying to connect what we've already covered in the past. Can you also cite common law judicial review? From Libby, lack of mandatory remedies. Okay, so what is the problem? Assuming that the ADJR Act does not apply. So going back to that, when might it be said that the ADJR Act is inapplicable? When can you say that the ADJR Act would be inapplicable? When may the ADJR Act not apply?
When it's stated that it's excluded.
That's one. What else? What else?
The Schedule 1 decisions.
Yes, that's one. What else? So if you go by Vicky here, the decision for it to be covered under the ADJR Act must be a decision of an administrative character made under an enactment. So in other words, if the decision was not made under an enactment, as held by the High Court in Australian National University versus Burns, then there will be no application under the ADJR Act. So in other words, for example, if the decision was based on a prerogative power and not on an enactment, or it could have been based on a contract following civil law principles, for example, then the ADJR Act will not apply. So the ADJR Act will only apply if it is a decision of an administrative character and that decision was based on an enactment. So if it is not based on an enactment, the ADJR Act will not apply. So therefore, which leads us to the question, assuming that a decision was not based on, so assuming that you have an administrative decision and it was not based on an enactment, will it necessarily follow that you actually have recourse to common law judicial review?
Yes.
Uh-huh.
I can't remember. I remember listening to the lecture today, and you said that the courts are always open to the challenge of the use of executive power, but I don't know where that authority comes from, like just a principle, or if there's a case, or...
That's right. So that's correct, Jacob. So the beauty with the common law judicial review is that an administrative decision does not have to be based on an enactment. So for as long as there is a decision made by an executive or an officer of the Commonwealth, then common law judicial review is available. So the decision does not have to be based on an enactment. However, the limitation, as we will know later, as we will see later on, as we see in the next 2 weeks, is that if you cite your application for judicial review on the basis of common law principles, you must be able to link that application for judicial review on the basis of common law principles to a specific writ. So in which case, traditionally, as far as common law judicial review is available, you have to cite, the specific remedy that you're asking for. In other words, if the legal remedy is not available, then it will not be useful to apply for judicial review under common law. So every time, therefore, you contemplate, so this is crucial later on in the final assessment that we have, it is insufficient for you to say that common law judicial review is available. It is critical for you to articulate the kind of remedy that you are seeking for, because the remedy might not be available. Or if you were to cite, for example, Section 39B of the Judicial Act of 1903, the remedies available under that provision would only be writs of mandamus, prohibition, or injunction. Now, the remedies are broader, obviously, if you speak of common law judicial review, because you can have common law, you can have equitable remedies there, or you can have remedies that are based on the common law, which are broader than those which are available under Section 39B of the Judiciary Act. Still, this early, I'm just flagging the point that even if you might be able to articulate that common law judicial review is available, there is a requirement that you must be able to show the effectivity or the efficaciousness of certain judicial remedies. You must be able to clearly show what remedies are available. And that is the topic which I think we'll be covering in week 11. Okay, so in sum, even if it is true that a decision, that judicial review might not be available under the ADJR Act because the decision was not based on an enactment, and therefore, common law judicial review might be available, it is still critical for you to be able to articulate the specific judicial remedies that you're hoping to get. Because in the absence of a failure to articulate the appropriate judicial remedy, then the application for judicial review therefore would be inefficacious. It would be ineffective. Okay, now, having said that, how about in terms of a merits review by the AAT? Why haven't we considered that? Couldn't we consider the possibility of merits review being undertaken by the AAT in this case? What assumptions do we make in order for us to say that the AAT may possibly be able to undertake merits review? Okay, from Libby, it is open so long. Yes.
It has to be a provision within the enactment.
Sorry, Libby, can you say that again? Sorry, Maggie, go ahead.
It has to be specified within the enactment.
Yes.
That avenue for the...
Yes, so that's correct. Although it might be argued that merits review would have been the best way for Mr. James here to question the administrative decision, the merits review would only be available if that specific enactment actually provided for a merits review remedy. In other words, only if that specific enactment provided that recourse can be had to the AAT for a review of the administrative decision. Because if that specific legislation, as Vivian pointed out, does not provide for that, then merits review would not be available. So when you think about it, if you were the lawyer, the first thing you need to ask is, merits review would have been the best remedy for this. And why is that? Why would, if it were available, why would merits review have been the preferable mode of attacking this decision? Assuming it were available, why would merits review have been preferable?
You can do a full de novo hearing.
Sorry, what was it again? Was that Catherine?
It is, yeah, because you can do a full de novo review, a full hearing of all the facts and evidence.
Yes. So that's right. So the beauty of, if it were available, the beauty of merits review is that you can attack a decision both on a question of fact as well as on a question of law. Is that correct? Can you actually attack a decision also on the basis of a question of law? I thought that was solely for judicial review. Just as a matter of, just reviewing what we've learned here. In a merits review, it is actually open for an applicant to question an administrative decision on a question of law. Or is a question of law exclusively something only for the courts to review? So in other words, you cannot attack an administrative decision in a merits review on the basis of a question of law. What is the correct answer there? Would merits review also include a question of law? So can you attack an administrative decision on the basis of question of law in a merits review? So we're kind of reviewing some of these concepts now. D says you can attack on basis of fact and law. The answer from Elizabeth is yes. Okay, what's your basis for saying that? So the answer is correct, yes. So even in a merits review can actually review a decision, an administrative decision, both on questions of fact and questions of law. And this was the ruling articulated by the court in Brian Lawler Automotive versus Collector of Customs of New South Wales. However, what we do know is that even if in a merits review, a question of law is also considered by the merits tribunal, or rather by an administrative tribunal, that finding on a question of law or that decision on a question of law by the administrative tribunal is not final and conclusive. Okay, it is not final and conclusive because only courts or Chapter 3 courts, as created under the Constitution, actually have the jurisdiction or the power to resolve questions of law with finality. So the only reason, however, why the court said in Brian Lawler Automotive versus Collector of Customs of New South Wales, why an administrative tribunal should actually have the power as well to resolve questions of law is because if that is not permitted, then you're simply saying that an administrative tribunal will be ousted of its jurisdiction by the mere expedient of a party saying that what is involved is a question of law. So if you do not, so the point made by the court is that if you do not allow an administrative tribunal to be able to make a preliminary finding on a question of law, then you're actually suggesting that by the mere expedient of arguing that there is a question of law involved, then automatically that administrative tribunal loses jurisdiction. That couldn't have been the contemplation of the law. So, in the case of Brian Lawler Automotive versus Collector of Customs of New South Wales, even when a legal question is actually raised, that will not oust the administrative tribunal of its power to resolve a question relating to an administrative decision. However, that finding of an administrative tribunal that pertains to a question of law is only provisional. It is not final because only courts or Chapter 3 courts created under the Constitution have the power or jurisdiction to resolve questions of law with finality. Clear? Okay. Do we have any questions for tonight? None?
Yes, I have a question on your message for today to us, saying that you started off by talking about the Wednesbury unreasonableness, and you said that this is just one facet of it.
Yes.
There's no evidence is one facet.
Yes.
Because I actually do find all the grounds of the ADJR Act rather confusing, because it seems like many of them overlap.
Yes.
And it's hard to decide in a question which ones to cite.
Yes.
In reality.
That's right. That's a very valid point. So what the ADJR Act has done is actually kind of to codify the statutory grounds for judicial review. So it makes it easier. So you have, Audrey, you actually have a child. You look so young. Is that your son?
That is my son. Say hi, guys. Say hi. Hi.
So young. Okay. I didn't realize you have a son. Looks so.
He's 5.
Okay. Okay. So going back, where was I? Yep. So the effect of the ADJR Act is to be able to enumerate the grounds for judicial review under statute. So it makes it easier. Instead of, because remember, the problem with the common law judicial review is that the grounds are in a sense quite more limited, because you can say that there are actually kind of two main grounds for judicial review under common law. It's either unreasonableness or on the basis of an error of law. An error of law meaning because the law is invalid or unlawful. So those are just the two grounds. However, the court has raised the question of whether or not there's actually a freestanding ground in common law, which relates to the question of whether or not there is a separate ground concerning on the basis of illogicality or irrationality. So that has been the other question that the courts have raised, especially in the case of Minister for Immigration and Ethnic Affairs versus SZDMS. And that is an unresolved question. In other words, the question is there a ground where under common law, a decision may be impugned on the basis that the decision is irrational or illogical without it meeting the standard of Wednesbury and reasonableness? Or does it mean that illogicality and irrationality are just ways of suggesting that there is Wednesbury unreasonableness in the decision? So that actually isn't quite clear yet, because some of the judges are prepared to say that irrationality and illogicality are separate grounds and not limited to Wednesbury unreasonableness. But having said that, even when one is able to argue that these are separate grounds, illogicality and irrationality are distinct grounds, the only reason why they can be said to be ground distinct from Wednesbury and reasonableness is because when a decision is really irrational or illogical, what it means is that there is involved an error of law. So that is, again, ultimately tied to the question of whether or not there was an error of law. Because remember, judicial review is limited only to questions that involve administrative decisions which are unlawful. So a decision is unlawful if there is an error of law. And the suggestion is there is an error of law if a decision is really illogical or irrational, without necessarily meeting the threshold of Wednesbury and reasonableness. But the bigger point that seems to be made is judges are uncomfortable with the idea that there is that freestanding ground. They're actually saying that irrationality and illogicality are just flip sides to the idea of Wednesbury and reasonableness. But even then, that threshold is quite high to meet. Okay, but the beauty of the ADJR Act is you have various grounds of to impugn a decision, and reasonableness is only one of them. Okay. Okay. Question?
We haven't done when it's unreasonable yet, have we?
I'm trying to think. Hold on, let me just check.
Because I'm not. I think it's next week.
Oh, that's actually next week. That's right. That's actually next week. Okay. So the thing about we need to remember is a lot of these concepts are actually interrelated, and that's the decision. And that's the reason why I actually think that administrative law is easier to understand. compared to constitutional law because they're just so related. A lot of times you're kind of amplifying the same concepts. So these concepts you've actually come across in previous weeks, and we're just digging deeper into them in the succeeding weeks. Unlike constitutional law, where there are so many disparate principles which you try to master. In administrative law, on the other hand, a lot of these themes actually are very repetitive. So when we try to take them up each week, what we're doing is trying to examine them in detail. But actually, it would have been possible for us really not to go into detail, because when you go through them in the previous weeks, you have a good sense of what they actually mean. So to an extent, it can be argued that administrative law is simpler because there are very few core concepts. And a lot of them is actually just repetition and going deeper into the concept, as opposed to constitutional law, where the principles are just, quite disparate and distinct from each other.
I thought that they introduced this illogicality because there's some of the Migration Act actually expressly excludes appeal on the grounds of unreasonableness.
That's right. So that's actually correct, B. So if you look at the previous Migration Act of 1968, there was a privative clause in the sense that law previously said that an appeal or a decision of the Minister for Immigration couldn't be attacked on the basis of unreasonableness. So there was a privative clause. So a privative clause is a clause which limits grounds for review. So that specific law, which is not the same as an ouster clause, because an ouster clause totally removes the jurisdiction of a court from reviewing a case. An ouster clause is unconstitutional and invalid. A privative clause, as found by the courts, is valid. What it only means is that a privative clause limits the grounds for judicial review. And in this case, in the previous Migration Act of 1968, the unreasonableness of a decision was not a ground for judicial review. And for that reason, because you couldn't attack a decision of an immigration officer on the ground that it was unreasonable, you didn't have a choice, but therefore to argue that the decision was illogical or irrational because of the ouster clause. And for that reason, therefore, there were instances when a decision of an immigration officer was set aside on the basis of the fact that the decision was irrational or illogical. But the Migration Act was subsequently amended so that unreasonableness can now actually be a ground for judicial review under the Migration Act of 1968, which wasn't the case before, if that was helpful. Okay. Questions, comments? So thanks, Lee, for raising that point. So that was actually the reason why that there was that question of whether or not there should be a freestanding ground concerning illogicality and irrationality as different from unreasonableness. Okay, any questions before we end tonight's tutorial? None? Okay, so going back to the release of the marks for the legal memorandum, they're still on, we're still on track to release the marks this Friday, late in the evening of Friday, because I have to finalize the grade book. Okay,
what do you mean by late in the evening, Manjo? Are you talking 6 p.m. or are you talking midnight?
11, midnight, almost midnight. So I'm trying to stretch the time when I need to release the grades because we're not yet done with the marking. So don't expect for the marks to be there by 6 p.m. They're likely going to be released late in the evening of Friday this week.
That's all right, mate. If you need a hand, just let us know. Open up Gradebook and we'll put our grades in for you.
Okay. Okay, then. So good night, everyone. I've seen a lot of very high quality legal memorandums, and I'm really impressed with the quality of some of the answers there. They were just fantastic, which is really good. So I'm happy to say that, you know, I'm seeing a cohort here of students who will become, you know, good additions to the legal profession, which is really good. The quality has really been good, really good, which wasn't really the same as it was last term. The quality of this cohort is really good, which is, and yeah, in fact, most of the people who are usually in the tutorials are the HD students. So, you know, the quality has really been good. So having said that, I'll see you on Monday of next week then. Thank you, everyone, and good night. Bye.
Thanks, Manjo. Good night.